Hello, everyone. I'm Bob Goulder, a contributing editor with Tax Notes. Welcome to the January edition of In the Pages, where we take a closer look at some of the content from our print and online publications. Our featured article for this month is The FATCA Wars, Jenny Goes to Court. Now, if you follow international tax developments, that headline, you will know exactly what it refers to. Yes, we're talking about Jenny's case, which is now pending before the UK High Court. And this is a fascinating legal dispute for a variety of reasons, which we are about to explore. Now, the very abbreviated description of this case is that we have a person born and raised in the United States who one day decides to relocate overseas. Now, that alone, there's nothing particularly dramatic or controversial about people moving around. After all, this is the era of globalization. People relocate. But then we have to factor in the US policy of citizenship-based taxation. And that creates some issues here. And I should point out that this standard of citizen-based taxation, the United States is the only country in the world that does that, other than the East African nation of Eritrea. The whole rest of the world, including all of our trade partners, they follow an alternate model, residence-based taxation. Well, what this means is that our US expat, Jenny Webster, encountered some unfortunate difficulties as she went about her life in her adopted home. And the ensuing legal challenges have been making headlines ever since. Now, we at Tax Notes have been profiling Ms. Webster's case on multiple occasions, and we're absolutely delighted to have her on the program today. Our other guest is also quite a notable personality in the international tax world. He's one of the premier legal experts in the intersection between taxpayer rights, data protection, and governmental transparency. He is Filippo Noseda of the London-based law firm Mishcon Durea LLP. And he also happens to represent Ms. Webster in her ongoing conflict. So we have them as our guests, and this is fantastic. Ms. Webster, Mr. Noseda, welcome to In the Pages.
Thank you.
Thank you for having us.
Let's begin. Jenny, the first couple of questions are directed at you. Can you just tell us your backstory, your negative? How did you become a UK taxpayer?
Well, I grew up in Maryland in the US and moved to the UK about 22 years ago in the year 2000 when I was 22. And I came over to study, and I met my husband when I was at university. And then when we graduated, we settled here in the UK in the Lancashire village where he grew up. And I work at a university as a research associate, and I do other freelance work, editing publications and supporting deaf students and deaf academics with their writing. And so I've been a UK taxpayer my whole adult life since I graduated university here in the UK.
Well, okay, so you are living and working in England and paying British taxes on your earnings as they accrue, as one would expect. How and when did you learn that you could still be on the hook for US taxes?
Well, it was in 2016 that I got a letter from my bank suddenly saying that I may have tax obligations in the US and that the bank was going to send information about me and my accounts to the US IRS. And I was really confused by this and did some research online. I'd never heard of FATCA, Foreign Account Tax Compliance Act, or anything to do with why they would need to send my data to a foreign tax authority where I hadn't lived since I was quite young. So they gave me a really short time frame to reply, so it caused quite a lot of panic. So I did the online research. I called some accountants, and I found one that said he could help me figure out, what to do and how to address it. So he did the tax forms that I needed to do apparently, and they said that I didn't owe any U.S. tax.
Okay, so you actually didn't owe any U.S. tax. Now, so if years go by and you didn't know about citizenship-based taxation, you had to take some remedial measures. So that's what you're referring to when you said you had to hire an accountant and
Yes.
take care of some filings. Yeah.
Yeah, he helped me do what they called the Streamline program, which involved filing 3 years of taxes and then 6 years of the foreign bank account reporting, which goes to the Financial Crimes Enforcement Network. And yeah, for all the years that he filed, I didn't owe any US tax. And of course, all my accounts were British, so they all went to, everything that I had went to this crimes enforcement network.
A lot of our listeners are probably thinking immediately in terms of double taxation. If you're earning some income and the UK is trying to tax it and the US is trying to tax it as well, that right off the bat sounds like a problem because you've got double taxation, which of course should be relieved or ameliorated to the greatest extent possible. In the US, when you think about the Internal Revenue Code, there's a section 911, which has a exclusion for earned income. A lot of our readers are probably thinking, hey, is that going to help her out to relieve double taxation?
Yeah. So my income is well below the 108 whatever $1,000 that it is. I just earned the average UK wage, so I was nowhere near that. Probably never will be anywhere near that threshold.
Bob, Jenny, can I jump in very quickly, because I had to do some research on the background of this, and the only 911 I knew, I wanted to have it in my garage, and so reading about the foreign income earned income exemption, it was interesting to find out that it was introduced in the 1980s at the height of a recession, and the US government was really trying to encourage Americans to go abroad, effectively to represent American trade interests. And at the time, it was $50,000, and then with inflation, it went up. So it's interesting that the government, rather than relying on double credit, too complicated, say, look, you go abroad. If you earn a modest living, we don't want to see you. Just go out and sell the world. And so now you have the FBAR and FATCA that effectively recaptures all those peoples. And just to put things in proportions, $108,000, we calculate how much that is in pounds. And according to statistics from the UK tax authorities, the equivalent of the IRS, we call it HMRC, Her Majesty's Revenue and Customs, about less than 10% of taxpayers in the UK earn the equivalent of £108,000 or more. We're going to see later that we asked the government for information. They didn't provide any information. So we can only make some conjectures. If we think if we assume that the US population in the UK matches the profile of the UK, the Brits in the UK, 90% of Americans in the UK would not owe any US tax by virtue of earning less than $108,000, the equivalent. But nevertheless, under FATCA, their information goes to the US as well, which is a bit of a misnomer to me.
Yes, because she doesn't owe any tax. And 90+% of the people in her situation would owe no US tax. And that's not because of the complex process of having foreign tax credits. That's just by virtue of Section 911.
Correct.
Which Congress put there for a very clear reason. Okay, let's talk about citizenship. There was a period, Jenny, when you were a dual citizenship, or a dual citizen, is that correct? US-UK citizen. And then what made you decide to do that? You started out US. What motivated you to become a UK citizen?
I wanted to be a UK citizen ever since I got married, and my husband and I decided to settle here. There was no question about that. So there was I became a UK citizen in 2010. There's kind of like a waiting period. You have to have indefinite leave to remain for a while. And then by the time I did it, then there was the Life in the UK test that you had to pass, and fees and things like that, and some forms that you had to fill in. So I got it in 2010. And it was never a question to be a dual citizen then, because I was, I had an American childhood and a British adulthood, and, dual citizenship just felt like normal and natural thing for me personally to have. So, then it was through learning about FATCA that it started to sink in that this was going to be a big problem going forward. And I don't, I had all these different filings and data transfers and things going on that I were just kind of like beyond me. And I couldn't afford this expensive help to always figure out what was going on. Every single financial decision was just going to be unbelievably complicated. And I was never able to find out what was happening with this data. I mean, what did this mean? Why was this being, sent when I didn't actually owe any tax? So I realized also I couldn't get an investment account. So me and my husband, I tend to do the finances for us. So I need, I like to have, be able to do things with my own money and with our money. And I couldn't open an investment account because of being a US citizen, for example. So there was just a lot of things I was hitting a wall with my US citizenship. And I thought, that it started to dawn on me in 2016 that, and just increased until 2018, by which time I had written to my MP, I had written to HM Treasury a number of times, US Ambassador, several members of Congress. I submitted evidence to the US Senate Finance Committee. I'd done freedom of information requests here to try to find out about FATCA, like the aggregates, what it was actually doing and how people could find out what was happening to their data. And I was just kind of at the end of my rope, and with a very, very heavy heart, in the late 2018, I applied to renounce my US citizenship.
Well, under the situation that you've just described, that seems like an entirely reasonable thing to do. Not being able to open an investment account, that would make my head explode. That would make all of our readers' heads explode. If somebody, the world came and said, no, you can't save for your retirement, I mean, that's harm. That's direct, actual economic harm right there. So
and it's particularly because of because interest rates are so low. I mean, responsible saving for retirement is going to involve investments. You can't just save in cash. They don't pay enough interest on cash anymore. So they're basically people in that situation that they just can't save for their retirement. Full stop.
No, it's just shocking if the implications of FATCA and citizenship-based taxation is that you have to save for your retirement by taking cash and sticking it in the mattress. That's something's wrong with the world if that's where you end up. Okay, my last question for you, Jenny, is it goes back to when I first heard about your case. We were in the newsroom here at Tax Analyst, and somebody tapped me on the shoulder and said, hey, did you hear about this person who's crowdfunding a portion of their legal expenses? And I had just never heard of that before. And that was you. What an ingenious thing to do. Tell us about that, just generally. You don't have to go into too much detail, but what was it like? Where did the idea come from?
Well, for those of us impacted by FATCA have formed this online community. So it's got people like me who are American immigrants who moved. A lot of people have moved at a young age like me, in their early 20s. And then others who left the US when they were babies or toddlers, who are accidental Americans. So we have a kind of an online community to support each other and help new people who are coming into this and panicking like most of us did. And helping them figure out what to do. So it was somebody in that group who runs a website in Australia called Fix the Tax Treaty. She sent me a conference panel video, and it had this conference panel that talked a lot about FATCA and data transfers. And one of the people on the panel was British. I found out, I loved what he said. It really resonated with me. So I looked online to find out who he was. And he's Philip Baker, QC, and I found out he had written a lot about this. And I just emailed him to say, thank you so much. I really liked what you said, and and thank you for speaking out about this. And he put me in touch with Filippo. And then over, I think, many months, we started talking on the phone, and I told him about my freedom of information request. And he had done the work with the predecessor to the European Data Protection Board. He had loads of experience doing this long before I ever knew about FATCA. And it just came, it arose out of that. And because I had been through all these avenues with the ICO, and I'd had the door slammed in my face so many times, the only way of really going forward was with, through the courts really. And the only way of doing that was crowdfunding. So it had to be done that way, really.
Well, it was a wonderful idea, and I wonder if you haven't just started a trend with your decision to do that. Thank you so much for the narrative. It's quite a compelling story. Now, Filippo, let's switch over to you. We have the factual background. Let's talk about the legal analysis here. I mentioned FATCA a few times, but your client, because she renounced her U.S. citizenship, is no longer subject to that statutory regime. So what is the basis for your current legal challenge here?
That she was. That she was American, and therefore, up to her renunciation of her citizenship, she was subject to this regime. And we know that her data was processed and was exchanged. Now, how many exchanges? So, with processed by the bank, maybe with the help of external providers, cloud services. From there, the information we know went to HMRC, which use some software, maybe internal, maybe external, maybe the cloud, which then send information over the internet through a system called IDES, International Data Exchange Software, developed by a company with close links to the NSA, went to the US. Notwithstanding the fact that she renounced her citizenship, that multiple stage transfer of data took place, and that exposed her to the risk of hacking, and also, we believe, was against the principle of proportionality on the basis that data was exchanged in circumstances where Uncle Sam did not want any tax from her. It's not as a result of Jenny owing tax to the US, owing tax to the UK. There is a double treaty, and therefore you can see that Uncle Sam might want to see how is it that she ends up paying no tax. It's actually Uncle Sam saying, we don't want to see you, 9/11, go. So even if even if data is no longer currently exchanged, violations of fundamental rights have taken place. And therefore, the legal basis for that is data protection legislation. We know that following the revelations by Edward Snowden, there was a big discussion about whether or not states should be entitled to collect process information of citizens on a bulk basis. And if you think historically, the idea came out of 9/11. States believed philosophically that they had a right to do that. And following the revelations of Snowden, the US government with Obama and in the UK, there was a big discussion as to whether that was right. And in the EU in particular, the European Parliament felt that the the pendulum had swung too much towards state powers. And so the GDPR, the General Data Protection Regulation, was voted into 2016 and entered into effect for all EU member states in 2018, which provides for some precise safeguards on how data should be collected. And if you forgive me becoming sort of philosophical, the backbone of that legislation is the European Convention of Human Rights, which is a piece of legislation, a multilateral convention that was signed in 1950, 5 years after the Holocaust, and at the time where Stalin was still around. He died in 1953. And it was really a philosophical piece of legislation by the West, saying that we differentiate ourselves from communism, which is communal, by putting the individual at the center of the political edifice, and then we build the state around it. And so Article 8 of that convention says that there is a fundamental right to privacy. In 1950, privacy was so important after totalitarianism. And so Article 8 says that that right is fundamental. Of course, it is not absolute. Of course, the state must be able to come into your house for an arrest warrant, but you need a warrant, you need a law, you need a public objective, which you have because FATCA seeks to fight tax evasion. And then Article 8 of the European Convention on Human Rights says that any limitation by a public authority of the right to privacy needs to be necessary in a democratic society to achieve the objective. That article was taken up by the European Union in 2000, just before the East European bloc, following the fall of the Berlin Wall, joined the EU. And the EU was effectively saying to former communist states, if you're coming over here, these are the principles we want you to abide to. So the EU effectively signed up a new convention called the European Charter of Fundamental Rights that replicated but modernized the old 1950 convention, because in addition to the right to privacy, it introduced also the right to data protection, because of course we had the internet in the meantime. And Article 52 of the European Charter of Fundamental Rights again says that limitations to fundamental rights, including the right to data protection and privacy, need to be necessary in order to achieve the objective. And now, fast forward to 2018 with the GDPR. The GDPR contains a number of principles, one of which is called data minimization, which says that personal data should only be processed to the extent that is necessary to achieve the objective. So, as you can see, there's a thread going through the whole thing between Jenny's case, her data, and the 1950s legislation. And so we now have two bits of legislation which have got extraterritorial effect, because FATCA effectively, through bilateral agreements, forces foreign banks to provide information to the US, either directly or indirectly, depending on which model agreement you have. And so extraterritorial. And you got this EU legislation that says EU data should not be transferred to a third country unless the data processing abides to the EU standards, including data minimization and necessity. So we are there, and that's the legal basis of our claim. And the jury's out on that one.
Yes. Now, you mentioned GDPR, which our readers will be very familiar with, but that is a piece of EU framework, really. And we've had Brexit. So just very briefly, can you touch on how Brexit affects the applicability of GDPR to this situation?
Since the UK joined the European Economic Community, later the EU, in 1973, a lot of UK legislation derived from the EU. And when Theresa May tried to decouple the UK from the EU, it became apparent that you can't simply leave the club, effectively renounce all the body of rules and pretend they don't exist and go back to your domestic law. Also, the EU, it's a huge trading partner for the UK. In data protection, if you do not abide to the principles of EU law, UK businesses, banks and others will not be able to do e-commerce with the EU, because the EU will not be able to transfer data to the UK. So what the UK did was to come up with a very strong slogan, take back control over our borders and our laws. But in practice, not much has happened, because under the Withdrawal Act 2018, the idea is that the existing EU legislation remains part of UK law. So effectively nothing changes. So the GDPR, we call it the UK GDPR, same thing. Save that going forward, the government and UK courts may have power to depart from that law. So and because of this continuity between EU law and what we call retained EU law, even case law from the European Court of Justice remains relevant. Now, you haven't got now hierarchically the European Court of Justice dictates to the UK courts how the UK court should behave. So there is no precedence anymore. However, when interpreting the retained EU law, if there is a case from the European Court of Justice, the UK judges are supposed to take that into account. They are free to depart from it, but there needs to be a reason for that. So going back to do a timeline, Jenny's, the UK, FATCA became law effectively in the UK in 2016. Why? Because you have FATCA, which is a US law. You can say whatever you want in the tax code, but the reality is that you cannot implement it in a foreign country unless you invade it. And so what really you need is for the other country to say, yes, we effectively agree, we plug into the system. And the way that happens is through IGAs, intergovernmental agreements, which are bilateral agreements whereby effectively foreign trading countries, trading partners says to the US, look, we switch on FATCA domestically. And the UK did that, the first EU country to do so in 2012. Interestingly, 2 months after the European Data Protection Authorities issued a damning opinion to say that FATCA was disproportionate. Anyway, this is what the UK did. The rest of the EU followed suit. And then it was effectively switched on in the UK in 2016. And therefore, that's when Jenny's data started to be exchanged. At that point, the GDPR was not in force yet. So we, under the claim, we are applying pre-GDPR case law and legislation. It's called a Data Protection Act 1998. There was a EU directive. Then from 2018 onwards, it becomes the GDPR with a lot of case law. And then we got Brexit. Now, interestingly, although the claim has been brought now following Brexit, Brexit is not relevant for us because the transfer of Jenny's data took place and stopped before Brexit. So Brexit is sort of a background noise in our claim. It's all effectively EU law.
Excellent. That's just the explanation that that solves all the questions I had about that. Now, when I was first researching myself as a contributing editor for Tax Notes, when I'm studying Jenny's case, I had this thought that everything's going to be fine for her because there's a part of the UK government called the ICO that's going to take care of her. Because she's a UK taxpayer, and there's a governmental body, ICO stands for the Information Commissioner's Office, that when you read about it, when you look at their mission statement and so forth, it seems like it's specifically set up to safeguard her interests. And nominally, it's an independent agency. So I get the sense, the fact that you're in court and you're litigating this, maybe my impression of the role that the ICO serves was a little bit naive. Now, in your experience here, how well does the ICO safeguard the interests of Jenny specifically or British taxpayers generally?
Well, a dyslexic friend of mine sent me a message to say, Filippo, you've got an email from the incoherent commissioner's office. It is incoherent because the mission statement is to be vigilant, to be a police man over government. It's supposed to be independent. And the reality is that the ICO has been happy to apply the GDPR and come up with fines and whatnot. And as the rest of the EU data protection authorities have been happy to when it comes to e-commerce. So the huge fight around Facebook and Max Schrems enriching his data is about, Facebook stealing my data, taking it into the US. But when it comes to governments, and that was before my time, when Jenny tried to get information out of HMRC and they said, transparency is an interesting principle. It goes one way. We want your data, but why should we give you our data? And HMRC said to provide you with our data would jeopardize our relationship with a foreign country. It's very much 007 kind of stuff. And so Jenny, before my time, appealed to the ICO, and the ICO sided with the tax authorities, again, applying a very 007 idea. If you read the ICO decision, it says, at the time of the request, the US was one of the closest allies of the UK, and therefore to provide information to Jenny is likely to prejudice international relationship with our friend. And that's odd, because the ICO should not give a hoot about politics, but it didn't. It's been subservient, we believe, to HMRC. And when we then appealed to the ICO and made them aware of a lot of case law from the EU that said, look, data protection is really important, you need to apply it, they sat on it for, I believe, 11 months. And then when pushed, they said, oh, sorry, we still need to get a policy input in relation to Jenny's case. Now, an independent body that asks for a policy input, in my book, ain't independent. And so we do feel that the ICO has let us and Jenny down. Now, you know, lawyers are advocates, they fight one corner, another person, the opponent, fights the other corner. If you look at a fight from the outside, you might say, look, in reality, truth sits in the middle. So you might say, Filippo, your judgment is clouded. If you go to the ICO, they say we are very independent. But if you look at really history, we found, oh, if I can open a bit of a can of worms here, through Jenny's connections, we came in touch with an accidental American called JR. And JR, in 2016, filed a petition with the European Parliament, just about the time the GDPR was being adopted, to ask the European Parliament to consider the extraterritoriality of FATCA and the implications for data protection. And we got in touch with him, and through him, we got in touch with a Dutch MEP called Sophie Interveld, who fought 3 or 4 years against the Commission. Again, transparency goes one way, to get hold of internal documents of the Commission in relation to FATCA. And we got hold of those documents, and they make for very interesting reading. The Commission later denied the existence of negotiations, but we saw that in 2010, even before FATCA became law in the US, the European Commission had active negotiations with the Treasury, with the Secretary of the Treasury, to say that there were concerns that FATCA could not be exported into the EU because of data protection, European Convention of Rights, and so forth and so on. And there were interesting letters by the European Banking Federations, the British Bankers Association, saying that FATCA was disproportionate. There was a letter by the British Bankers Association to say that the board of directors of our members simply cannot sign up to this unless these issues have been resolved. And the European Commission was really trying to mediate and asked their independent data protection body, now that's independent with a capital I, to look into it. And in June 2012, so 2 years after FATCA came about, but before the IGAs were signed, this body came up with a 5-6 pages opinion in which it says that FATCA needs to be seen as necessary from a EU perspective. And nearly verbatim, that body said that the bulk collection of data of citizens without any conditionality of tax evasion indicia is not the right way to achieve FATCA's objective. And that body went on to say that less invasive alternative systems need to be considered. 2 months later, the UK signs up to FATCA. So that's the UK already playing its own way, but also the UK never really quite understood privacy. Although the European Convention on Rights was really the brainchild of Churchill. So in 2012, the UK government decided to act against the advice of the European Commission and the independent data protection bodies, opening a floodgate, because at that point, the European Commission said, forget data protection, it's level playing field. We can't have the City of London doing business with Americans, and Paris and Frankfurt are cut out. But it's in, and at that point, everything changed. And also the French finance minister who signed the French FATCA became then appointed European commissioner. And clearly it was impossible for him to say that what he had done was against fundamental rights. And we've seen a cover-up. But back to your question, it was very interesting to see that the European data protection authorities had very independently looked into this matter and said, this doesn't work. Asked with a simple question of, give us information about aggregate data, we'd like to know how many people subject to FATCA are not subject to taxation. HMRC plays politics, and the ICO says, absolutely, that's fine, because that would be prejudice the relations with a very close allies of us. So incoherent, incompetent commission office, I don't know. It's called the Information Commissioner's Office, but there's no information coming out. And that's a big problem in my view.
Well, I think that comprehensively answers a question about whether the ICO is safeguarding the interests of taxpayers. I think in this case, it looks like it was more keen to throw the taxpayers under the bus. Now, they're supposed to be an oversight body, but who's overseeing them? I mean, if you look at the European Union, every country is going to have its national data protection agency. Isn't there some piece of the EU infrastructure that oversees them? Was it the European Data Protection Board?
Correct. The opinion issued in 2012 at the behest of the Commission was published by the Working Party Article 29, not very sexy name, but named after an article of the pre-GDPR directive, Article 29, that said that there should be an independent body, an umbrella organization bringing together all member states' national data protection authorities and advise the Commission on legislation. And that's exactly what they did. With the GDPR, this WP29, Working Party 29, got, and it was chaired by a very fiery French lady who, in the dying days of the WP29, sent a very stroppy letter to the European Commission and the OECD to say that automatic exchange of information was very worrying, and that the OECD and the European Commission were not taking into account case law developments. And soon after she wrote the letter in December, in January, that body disappeared and was, because Article 29 of the directive disappeared, and it was replaced by the European Data Protection Board. Its remit is similar. It has to advise the Commission on data protection issues and has to coordinate the work of national data protection authorities. There isn't a right by that board to take legal action. But we've been trying now for 3 years, and we published on our website, if you look at mishcon.com correspondence, you will find out about 110 letters we wrote to the EU asking the European Data Protection Body to take seriously its duty to supervise and coordinate. We say there is no coordination because you have bodies who really are not working in line with the GDPR and are working against case law, but they're not doing anything. And we found evidence of reports, more than evidence, it's reports of the European Commission meddling with the work of the EDPB, the European Data Protection Board, because they want FATCA to remain. And the reason why the EU wants FATCA to remain, it's partly to do with the US, but partly because out of FATCA came the common reporting standard. And clearly, it is in the EU's own political interest to receive information from third countries. And that becomes very complicated because 3 days ago, we sent out letters to commissioners, Gentiloni and Jourova, asking them for a right to reply in respect of evidence that we've seen through documents unearthed by this Dutch MEP, Sophie Interveld, that very clearly suggests that the European Commission, the current version, the old one really tried to negotiate with the US, and this current administration went on record to deny the existence of any negotiations with the US against any clear evidence, and they're trying to bury everything under the carpet. And we believe that, like the ICO, the European Data Protection Board is not independent and is not discharging its duties. Now, what it did last year, following the Schrems case concerning Facebook, it issued a statement inviting member states to renegotiate the IGAs to the extent that there is a breach of the GDPR. Now, that is an interesting view, because if a right is fundamental and it's a right, it's not an option. And why would you leave to governments the renegotiation of a political instrument that infringes fundamental rights? So we believe there is effectively an endless ping-pong game which has been played very consciously to effectively frustrate any attempt to bring justice in this area. It's very, very conscious, we believe. Or if not conscious, there is a staggering level of incompetency at the heart of the mechanism that is supposed to enforce the GDPR.
Very well said. I mean, based on what you just said there, to me, it sounds more like an intentional ping pong game than something that's accidental. But who knows? We don't have a crystal ball. We can't gauge people's motives. But no relief for taxpayers from the ICO, and really no relief from the European board. That's a very soft response to sort of encourage the countries to renegotiate the bits that might be problematic. You'd hope for firmer action there. My next question, I want to talk about Freedom of Information Act. In the US, we have this act, we call it FOIA. It's an acronym, FOIA, Freedom of Information Act. Some countries have something very similar to that. They call it the Open Records Act. What role did that play in this litigation?
Well, Jenny asked HMRC to disclose aggregate data based on a FOIA request, Freedom of Information Act 2000, and the HMRC and the ICO hid behind an exemption. There is now a furore in the UK because there is a lot of evidence that suggests that government is suppressing information to citizens. So this is where things become interesting, and I do like my history and I do like my philosophy. In 2013, when FATCA was being debated in the EU, the then Prime Minister David Cameron called a GA meeting in Northern Ireland, a place called Lough Erne. And one of the things that they said that should happen is that there should be public registers of beneficial ownership because we need to have transparency. But they said transparency goes both ways. And so if you look at the communique by the G8 leaders, and I tell you it's G8, not G7, because G7 is G7 plus Russia. So Putin was there. They came up with the idea of an open charter, open government charter. And it goes grandiloquently like this. Government should be accountable to citizens, and therefore there should be an open charter. Information should be given to government. Now, if you have a meeting with Putin there, you know that that's not really going to happen. And David Cameron, well, I don't, I can't make, but it was not very smart, I think. But there is a negation. There is a negation by governments of the right to provide for transparency. And we know that in the UK, this government has been very active in trying to stifle any criticism by citizens following a number of court cases that went against the government. And the government is really trying to say to judges that they should not meddle and citizens should not bring claims against the government. If you watch the news now about our Prime Minister's shenanigans in relation to COVID, you're not surprised. I think that we are, although FATCA is just about tax and Jenny's data is just about bank accounts, if you think about that, I think that there is a really huge peril that we are at a breaking point of a democratic process where citizens are not allowed to ask state for information, and state is imposing a lot of transparency on citizens based on a very noble objective of fighting against tax evasion, but using a hammer to crack a nut. FATCA was introduced, I'm Swiss by background. I was a Zurich lawyer before I came to the UK, and clearly what was happening in the 1990s and what came out of the Levin report on tax evasion and Swiss banks and whatnot was despicable. Diamonds being taken offshore through toothpaste tubs and that kind of stuff. And so FATCA was designed effectively to prevent fat cats, rich Americans, from hiding money offshore. And interestingly, in 2010, the British Bankers Association, the European Bankers Federation used to say, but this has gone too far because you're now capturing anyone, even people who do not pay tax and people who do not have money offshore. Because to say that Jenny, whose bank is 500 yards from her home, that she is hiding money from Uncle Sam by placing it offshore, it's a bit rich. And so disproportionate, what is it? Nobody's saying that FATCA is wrong. Nobody says that FATCA, the principle is right. It's the way the governments have gone about it that is wrong. A very noble principle has been applied disproportionately, and governments do not want to be held accountable for that. And that is the big problem. And so Freedom of Information Act has turned out to be, on the face of it, toothless, because Jenny's Freedom of Information request was turned down. But we actually, it's interesting because it does show that it works in the sense that there's no information, but at least there is a trace of lack of information. And so there is an accountability system there.
Okay, Filippo, now the world is fairly well informed about Jenny's case, particularly in Europe and the United States. But let me ask you this, with all that we've talked about and all that we've had to absorb here from this discussion, what does a successful outcome look like for you and your client? How is justice achieved here?
It's simply that we would have a determination that Jenny's rights have been violated, and that's the end of it. And then it's for others to decide what that means for the bigger picture. Now, I've been philosophical about the past. I could be philosophical about the future, but the reality is that this is an individual claim by an individual person who believes that her individual rights have been violated. That individual violation of individual rights must be ascertained by a court. If that happens, there may or may not be ripple effects. A government might feel that Jenny was in a completely isolated and unique position, or governments or other claimants might feel that actually that judgment might apply to them as well. But it's not really for us as advocates to then start playing politics. This is not a public interest case. This is an individual case that attracts public interest. It's a different thing. So Our aim is to get a nice judgment to say, yes, the ICO has not done its job, HMRC have not done their job, Jenny's data were collected, processed, and sent across the pond in a way that breached a fundamental right, period.
Excellent. There you have it. Counselor Filippo Noseda of the law firm Mishcon Derea, LLP in London. Thank you for your comments. Our American expat, Jenny Webster, thank you for joining us as well. We will continue to monitor this story because we know that our readers are very interested in the future here and what happens. So thank you very much for joining us. And again, the article in question is called The FATCA Wars, Jenny Goes to Court, and you can access it in the Tax Notes archive. Again, thank you so much for joining us and sharing your thoughts.
Thank you, Robert. Thank you.
Thank you for having us.
Want more like this? Subscribe for more tax videos. Special thanks to our executive producers, Jasper Smith and Paige Jones, and showrunner and video editor, Jordan Parrish.